Well, thank you everybody for joining us today. This is Allie Orwig with the Indiana Rural Health Association. We've got a great presentation for you today from Grant Achenbach, who's with Krieg DeVault. We also have our policy and legislative guru, Dan Hardesty, on the call. We will go ahead and get started here in just a second, but I do want to remind you of a couple little housekeeping items. First, if you have any questions during the session, please feel free to put those in the chat or the Q&A function. We will keep an eye on both of those and present Grant with the questions as they come up. Alternately, if you would like to wait until the end of the presentation, you can also, again, use chat or Q&A, but you'll have the option to use the raise hand function. We can unmute your line and you will be able to ask questions verbally if you prefer. We will be recording today's session, so if you're not able to join us for the whole time, or if you want to share it with a colleague afterward, it will be available on our YouTube channel by the end of the week. And with that, Grant, I am done with announcements, and I will turn it over to you.
Great, thanks, Alec, and everybody. Can you hear me okay?
Yes, sir.
Great, thank you. Thanks all for the opportunity to present to you again. I think I joined you last year for a similar presentation to wrap up 2023. And now that we concluded the 2024 legislative session of the Indiana General Assembly just over a month ago on March 8th, the wee hours of the morning, it is now time for our 2024 legislative update. So again, my name is sorry, let me get my slides set up here. My name's Grant Achenbach. I'm an attorney and a lobbyist at Krieg DeVault. We've really enjoyed representing the Indiana Rural Health Association over the last couple of years and enjoy that relationship. We thank you all for the work that you do in the healthcare space, particularly in our rural areas. And it's been a pleasure to work with Kara and Dan and the team at IRHA. So thank you all for your input as members. And the chance to represent you all and to speak to you here again today. As I mentioned, I'm an attorney. Most of my practice is in the government affairs space. And that's where my background is as well. In law school, I worked on the legislative staff, went to school in the evenings, and I worked for the chair of the House Health Committee. So kind of got a front row seat to many of these issues and the dynamics in the legislative process through that experience. I then was the lobbyist for the Indiana State Medical Association for a number of years before joining Krieg DeVault, and at the firm here I both practice law, about 30% of my practice, about 70% of my practice I'm in the State House lobbying. So just like the General Assembly session, our world is a bit cyclical in terms of it's all hands on deck 24/7 in the State House, and then we leave and after the session adjourns, and we're kind of on the circuit here talking about all of the laws that have been passed and then implementing them come July 1. So hopefully this will be a chance to learn about what you and your organization should keep an eye on as we approach July 1, which is oftentimes the effective date of new legislation. My colleague, Amy Levander, is not unable to join us today. She's out in Washington, D.C. Today for another obligation, but she's also one of the healthcare lobbyists on our team and the chair of our government affairs practice, and long been an effective healthcare lobbyist in the State House. So she's also part of our team. And then just a quick plug, this is our government affairs, our full government affairs team. So just a roadmap for today's session here, now that we've wrapped up sort of the introductions. I'll give us a real quick overview of the legislature and the legislative branch. And then I'll talk about kind of the backdrop, the important kind of backdrop, political issues, underpinnings of the 2024 session and kind of how the legislature approached the session. Then we'll dive into several bills that were passed during the 2024 session. I'll give you hopefully some digestible material to take back and flag for your organizations, and just cover each of those bills at a high level. And then we'll talk about a few of the bills that were of note to the IRHA and IRHA members that did not pass this year, and some of the nuances there. Oftentimes, our legislature, meets every year. And so sometimes things that are introduced but don't pass are a good indicator of, foreshadowing in the future and bills and legislative topics that will pop up in the future. So we'll discuss a couple of those that are of particular importance to our space. And then we'll do kind of a looking ahead to the next year's session, as well as sort of a political wrap up here, and what we can expect to see develop over the rest of the year before we approach the 2025 legislative session, which will certainly be a very important one for healthcare, as we'll get into here in a minute. So as many or most of you, I'm sure, all know on this call, at the state level here, we have a part-time General Assembly. So that means that all of our legislators, we have 100 House members and 50 senators, all of them bring their unique experience as having other day jobs, other professional backgrounds to the legislature. So we have, our legislators run the gamut of from attorneys to a lot of small business owners to folks that are retired to even some healthcare providers. In fact, we have some of the most influential folks in the healthcare space are physicians that are retired or still practicing. We have 2 in the House and 1 in the Senate. So they really bring each of their unique experience, and a lot of times the subject matter, depending on what's being discussed, and the subject matter, caucus members, legislators will look to their colleagues that have experience in the space as sort of a guiding light on those issues. So again, 100 House members, they're elected every 2 years, 50 senators serve 4-year terms. In the House, we have supermajorities, Republicans in each of the House and the Senate. In the House, we have 70 Republicans, 30 Democrats. The Speaker of the House is Todd Houston. And as I mentioned before, one of the legislators is a retired general surgeon, Dr. Brad Barrett, who I mentioned here is because he has is the chair of the House Health Committee, which is the committee of jurisdiction over a lot of the issues that the Rural Health Association deals with. So to have that healthcare expertise is certainly a benefit. In the Senate, we have 50 senators, also supermajority split, a little more, even a little more so here in the Senate, 40 Republicans, 10 Democrats. The president pro tem of the Senate, who is in charge of the Senate and runs the floor proceedings when the lieutenant governor is not there, is Rod Bray from Martinsville. And so this year, being an election year, half of the senators are up for election. So again, I mentioned supermajority a couple times. What does that mean? That simply means that both chambers can achieve a quorum with only Republican members of the body present. So 2024 was what we call a short session. It occurs in even numbered years, and by statute, the session must conclude by March 14th. Long session, the only really constitutional mandate for the legislature is to pass a budget every 2 years. So there's been some debate about whether we even need a short session. Long sessions occur in odd numbered years, and they must conclude by April 29th. And again, they, per the Constitution, must pass the state's 2-year budget. So with that sort of high-level background, the way the legislature viewed this session was largely in light of the contested primary for on the Republican side for governor coming up here in May. And so, as I'm sure many of you have seen through the flood of advertisements and mailers and just everything since last fall, kind of hitting you all angles. We obviously have a very contested primary on the Republican side, and that's because a lot of folks believe that the person that wins the Republican primary is going to go on to win the general election. And so, we have had since 2016, the Holcomb administration, and now this is the first time in some time that we've now had a contested primary here. As you'll recall that back in 2016, when Governor Holcomb was first elected, that was when then Governor Pence was tapped to be vice president, and so that set off all of this into motion. And so now we have this hotly contested gubernatorial primary, and the legislative leadership's mandate to their members was that they wanted to come in and deal with very simple issues that followed up on bills passed in 2023. The speaker was saying we want to do, we want to work on implementation and, technical cleanups. And then Senator Bray was, said multiple times, we want to do more what he would say, what he would call blocking and tackling. So simple issues to keep the legislature out of the limelight, because the last thing that the legislative leaders wanted was for issues in the legislature to become sort of a battleground for those gubernatorial candidates in the gubernatorial primary, which is happening, as the legislature is in session. That sort of led to this concept of bill limits, which historically the House, because they have 100 members, and obviously we only have a certain amount of time to implement issues or to pass bills and hear bills, they've traditionally sort of limited themselves to having a rule within the House that in long sessions, House members will only introduce 10 bills, and they will only introduce 5 bills in the short session. The Senate, on the other hand, because they have 50 members, they've not really regularly done any sort of bill limits. Sometimes in short sessions, they'll limit themselves to 10 bills per member. This year, both caucuses really kind of trimmed down or really cracked down on this concept, and both chambers had directed their members to only file 5 bills apiece. Now, there's some leeway granted to issues that have been studied over the interim, issues that have been that were carried by chairs. Committee chairs were allowed to have a couple extra bills, but this is by and large supposed to be a very short and sweet session. Another issue that sort of cast a shadow over the entire session was in December at a meeting of the State Budget Committee, which is where the fiscal leaders of the House and Senate meet with leaders of the state budget agency and hear testimony on issues, and sort of they hear forecasts for projections of tax revenue and Medicaid expenditures. At the December meeting of the FSSA and Indiana Medicaid announced that their budgetary forecasting for Medicaid expenditures that they presented earlier in April of 2023, which had a lot of impact on the budget that was enacted in 2023. Their projections for Medicaid expenditures were off or erroneous by about $1 billion. As you can imagine, that is not a number to sneeze at, and there has been growing concern about Medicaid expenditures and the inflation of Medicaid expenditures generally, and this created even more so, or that dynamic kind of tenfold. So we went into this session, anything to do with Medicaid, at the end of the year there, we had to go tell clients and share with stakeholders that if there's any sort of fiscal impact, particularly in the Medicaid space, it is going to be a very tough road ahead for any legislation. So the gubernatorial primary, the Medicaid fiscal issues, one last thing about the Medicaid fiscal issues, this being a non-budget year, legislators are very hesitant to sort of open up the budget. So essentially, there's concern that what's Indiana Medicaid going to do to kind of stem the spending until 2025, when legislators can revisit this issue and take action then. So again, yet another reason to avoid issues in the Medicaid space that dealt with funding. So those two issues, again, the gubernatorial primary and that Medicaid forecasting error, really overshadowed the 2024 legislative session. And so now we'll dive into some summaries of the major healthcare bills that passed this session. One thing I'll note, these first 2 bills that we're going to cover here, Senate Enrolled Act 132 from Senator Brown, And then the next bill will be House Enrolled Act 1259 from Representative Barrett. Because of what I just described to you in terms of the bill limits and the fact that committees in the short session, which ended on March 8th, even though they had until March 14th, but this time kind of compacted everything into a very small number of bills. So as I was going through and preparing for this, I noticed we have kind of a smaller number of bills here than we usually do, and that's because a lot of concepts kind of got mashed into a couple bills here that typically perhaps would have been standalone issues or bills passed through the process. But some of those dynamics sort of led to both the House and the Senate sort of vetting these issues en masse and then putting them all into two large bills. So first one I'll mention, Senate Enrolled Act 132, which was titled Professions and Professional Services, dealt with a variety of healthcare issues. I think first and foremost, many of you may be aware, depending on your your patient population and the services you provide, that Indiana is moving their long-term services and supports under Medicaid into a managed care model. So that means everything from institutional settings like skilled nursing homes, to home and community-based services like assisted living and home health, and attendant care services that are provided to folks in the home on Medicaid or a Medicaid waiver. That population is being shifted to the managed care model. This has been announced a couple years ago, and it's been a very long implementation process. 3 managed care entities have been selected: United, Anthem, and Humana. And that program is set to go live on July 1 of 2024. And currently, the administration is in the process of starting this claims testing, which we'll talk about here, and also just the MCs are getting providers under contract and pushing members that will be covered under this managed care model to enroll with the different health plans. So as we've seen in some other states, and as the IHCA, who's the association that represents long-term care providers, testified, one of the issues when this has been done in other states has been those initial 6 months of the program and sort of the bumpy road that this massive technical overhaul can lead to in terms of just getting providers paid on time. And so there's serious concern based on experience in other states that there would be issues with payments lagging to providers, with how this whole claims process would work to go from this fee-for-service model under Medicaid to now submitting claims to 3 different managed care entities. So the bill establishes, this Senate Enrolled Act 132 establishes a temporary emergency financial assistance program for providers that really, it's effective upon passage, and it requires Indiana Medicaid to set up this claims testing process so that providers can jump in and start essentially practicing submitting claims to the managed care entities. And then it establishes various triggers related to, depending on if providers have not been paid per the contractually required timeframes for the managed care entities to pay providers, or if they've got a certain amount of certain percentage of claims have been denied. There are all these triggers into place where if a provider hits one of those triggers, then they can apply for and receive temporary emergency financial assistance, which is essentially a block payment based on the 6 months of revenue received from Medicaid prior to managed care go live that will help that provider kind of smooth out over the next several months of implementation until those issues with the managed care entities can be resolved. So that could very well, depending on how this rollout goes, starting on July 1, that could be a lifesaver to providers who are in the home health space or assisted living or nursing facilities and are having issues getting paid from the managed care entities. So that was certainly something that was prioritized by the legislature. While this may sound like it does have a fiscal impact, since this is moving to a managed care model, the legislature was able to reach a comfort level with the Indiana Medicaid to understand that, okay, these managed care entities are, being paid their fee to manage all of these patients that they're assigned. So there's really not going to be a direct fiscal impact on the state. Senate Enroll Act 132 also did a variety of other things, including it clarified last year the IRHA worked on provisional credentialing, so that if you're trying to credential one of your providers with a managed care entity under Indiana Medicaid or a commercial plan, and they're not credentialed within 15 days, they're deemed provisionally credentialed until their credentialing application can finally get approved. There was some cleanup there in terms of specifying that those 15-day timelines are business days, not calendar days. Another provision, which is the last bullet point on here, that IRHA specifically weighed in on was a requirement in our telehealth statute that providers that are physically located out of state treating Indiana patients, previously they had to submit a telehealth certification to the professional licensing agency, attesting to the fact that they submitted to the jurisdiction of the laws of Indiana relating to scope of practice and our med-mal laws and system. And that over time, that was enacted back when telehealth kind of first came into play, and as states were first passing telehealth statutes back in 2016. And that has over time become sort of more of an administrative burden than something that's beneficial. And so this bill removed that telehealth certification requirement, and just said that if you're an out-of-state provider treating a patient in Indiana, you automatically, by treating that patient that's located in Indiana, consent to the jurisdiction of Indiana. And it just removed the requirement to file another form. So I believe that's effective July 1. So as you work with providers, maybe you're in a border area, or you have a group that provides telehealth from out of state, that should make things easier in terms of getting those arrangements set up. There were also some dental provisions in this bill regarding dental insurance. Specifically, one of the elements that was more hotly contested in this bill was a provision that requires dental insurance carriers to honor assignment of benefits for out-of-network dentists. We were seeing some sort of a lot of concentration in the dental insurance market, which was allowing carriers to kind of force providers into these really low fees or be out of network, where the plans even had even more leverage to drive their covered lives to in-network providers. And so that was an attempt, by forcing them to honor assignment of benefits, an attempt to maybe more level set the playing field there in terms of negotiations between small community dentists and the large dental insurance carriers. Moving on to House Enrolled Act 1259, this started as a bill that was really focused around nursing education and removing some of the barriers in the nursing workforce pipeline, and then ended up having a couple other items tacked onto it at the end of session. So first and foremost, it removes previously there was a 50% cap on the amount of part-time faculty that four-year nursing higher ed institutions could have. Essentially 50% or more of their faculty had to be full-time faculty. And so the thought is removing that cap, which was in statute, sort of modernizes our nurse training educational model, and also allows for there to be more faculty that can either afford to teach or have time to teach, and so thereby expanding sort of this pipeline for nursing education, so that we can train more nurses and get them into the workforce. And I think it's no secret that there's currently a challenge recruiting and retaining nurses here in Indiana. I think it's a shortage that's occurring across the nation, and certainly here in Indiana as well. It also repealed a requirement that nursing preceptors, so those that kind of help with on-the-job training for other nurses, have at least 18 months experience as a registered nurse. That was previously in statute and administrative rule, and now wherever those nurses are employed, their institution or their employer can determine who is qualified to be a preceptor for other nurses in training. Another thing I'll mention that I couldn't quite fit into the bullet points here is there was a change a couple of years ago, I believe in 2022, where the legislature essentially made it easier for foreign educated nurses to come into Indiana and obtain a license in Indiana. Unfortunately, the way that it was drafted, there was some confusion, and so it essentially professional licensing agency really only applied those changes to expedite that process to nurses who were foreign educated and then had a license in another state in the US and were coming to Indiana. And now the change in House Enrolled Act 1259 allowed for that expedited pathway to be available to nurses that are coming in by endorsement, or those that were licensed in another state, and also those nurses that were that are coming in by examination or coming in to take the NCLEX and get licensed here in Indiana for the first time. So those were sort of the nursing provisions in House Enrolled Act 1259. And then as for the other elements that were included in this bill, it resets or allows the Department of Health to grant hospitals extensions for filing their annual fiscal reports. Those are due a certain time each year, and what we're hearing from hospitals is that sometimes the financial information that had to be reported was getting held up with their auditors, and there was sort of nothing that these hospitals could do. And so previously, when there was a lot of scrutiny on these fiscal reports, that was kind of sparked by this whole healthcare cost debate. The legislature had removed the ability for IDOH to grant hospitals extensions for this. And now, because of the challenges that we've seen over the last few years, this bill allows IDOH to once again grant those extensions for the annual fiscal reports. It also, again, this was kind of tied in with the whole healthcare cost debate, but this bill also specified that claims data is owned by plan sponsors of health insurance plans. So essentially, it's saying that if your employer pays for your healthcare coverage, your employer owns that claims data and can utilize that claims data however they see fit to, help try to narrow in on, what they can do to better serve their employees. Because previously, believe it or not, the insurance companies that would be the third-party administrator for those plans were saying that they own the claims data and that employers could not get to that. And so that is a thought that it will help employers have a better understanding of, what they're paying for healthcare, and then also challenges faced by their employee populations to better tailor workforce wellness measures and things of that nature. And then finally, interestingly, it established a therapeutic psilocybin research fund that can accept donations from other entities to help research institutions in Indiana study its use for mental health and other medical conditions. Psilocybin is a substance that may be up for reconsideration for rescheduling at the federal level. And so the thought here, there was a lot of testimony about the impact that this can have, particularly among the veteran population, those struggling with PTSD and other mental health issues. And so the legislature wanted to put this in place to the extent that it is possible to receive donations and supplement the work of our research institutions here in Indiana on that topic. So I know I covered a lot of ground on those two bills and spent a lot of time on those two, but those, at the end of the day, those two pieces of legislation, there's a lot of time spent on them. Not all of the time on each of these issues was spent talking about these specific bills. Some of these provisions were in other bills and then kind of all got lumped in to Senate Enrolled Act 132 and House Enrolled Act 1259. Kind of at the end of session there, but That's just the mechanics of a short session and a short session that in which the legislature decided to limit the number of bills all of their legislators filed. So we had a couple omnibus healthcare bills there. Another piece of legislation that really that a lot of time was spent on this bill, and really there are a lot of concerns raised about this, and I think not all of them, the concerns were acted upon. I think there's more of an intent to kind of see how this plays out. But Senate Enrolled Act 9 puts in place a notice requirement for healthcare entity mergers. We've seen across the country that a concern about rising healthcare costs has highlighted concerns about market concentration in the healthcare space, both on the insurance side of the industry and the provider side of the industry. This particular bill, or this consolidation concept, was discussed over the interim during the Healthcare Cost Oversight Committee that was chaired by Senator Garton, who's the Senate Republican floor leader and the author of this bill. And so this concept came out of those discussions and concern about market concentration. And this was Senator Garton's attempt to sort of deal with that issue and bring more transparency into that process. There are a number of other states. I can't remember the topic or the number of states off the top of my head, but I want to say 20 some other states have similar laws. And it simply requires a healthcare entity to notify the Indiana Attorney General's office or the Office of the Attorney General in the case of a merger or acquisition, and to provide that notice 90 days in advance of the merger or acquisition taking place. Now, that may seem simple enough, but I think that the concerns here really had to do with some ambiguity in regard to what is the definition of healthcare entity? What is the definition of a merger or acquisition? How broadly are we interpreting these terms? And some of these terms are, are undefined further. And so there's a lot of questions about implementation here. How's the Attorney General going to view, say we transfer a very expensive piece of equipment from one facility to another facility? Is that considered an acquisition? And I think there are a lot of outstanding questions on some of those topics that are raising concerns. Another concern is this timeline of 90 days prior to close. Is the Attorney General's office only going to enforce this for deals closing 90 days after July 1, which is when the bill goes into effect? Or, if you have a deal that's scheduled to close July 2nd, do you have to give 90 days notice now? Or how are those timelines going to work? Another element of this bill, the reason for this sort of 90-day notice is the bill says that the Attorney General will have 45 days after receiving the notice to analyze analyze the situation and provide written advice that is supposed to be confidential to the parties involved as to whether there are any antitrust concerns. And obviously there's kind of a concurrent federal process for this antitrust issue and on certain mergers and acquisitions. How does this 45-day timeline, if the Attorney General's office decides to not issue any findings as to whether or not there are antitrust concerns, then can you go ahead and close? Or if they say there are no concerns, can you go ahead and close within that 90-day window? Maybe on day 46 or 47. These are all questions that are unanswered. One more important element of this that I should have mentioned earlier is that this applies to mergers or acquisitions that involve value of $10 million or more. So, smaller transactions will not be required to provide notice, but in some instances, in many instances, when healthcare entities are involved, this issue is going to be triggered. And so I think at the end of the day, it's important to notify, the folks in your organization that are in charge of maintaining, acquiring, or, selling assets, acquisitions and mergers, and also talking with your counsel when such a transaction is contemplated to make sure that you're tracking the latest developments. We're hopeful that the Attorney General's office will issue some guidance to specify how they view this, but that's not a certainty. So just keeping a close eye on how this is going to be implemented will be key for dealing with this legislation. The last thing I'll mention here is that I know there's a lot of consternation about some of these transactions can be very sensitive in terms of the confidentiality of information involved. And concerns that could come from the disclosure of this information for employees of a particular provider or something like that. And the bill does specify that information provided to the Attorney General's office, and if the Attorney General's office decides to ask for additional information through a civil investigative demand, anything related to notice provided regarding a merger acquisition is to be strictly confidential. And so, we're hopeful that those confidentiality provisions can prevent that from being a concern in the long run. So again, I think those three bills really sucked up a lot of the oxygen in the legislative process in the healthcare space. So I'm going to, just to be cognizant of everyone's time here, I'm going to click through a couple of these other pieces of legislation and spend a little less time talking about them now that we've covered some of these issues. So forgive me, I'm trying to find my clicker here. House Enrolled Act 1426 is a bill regarding long-acting reversible contraceptives, and it requires hospitals with maternity units essentially to offer long-acting reversible subdermal contraceptives to any woman that gives birth in the hospital that is eligible for or receiving Medicaid assistance. There are exemptions if the hospital has a faith-based objection, but it requires at a minimum that those long-acting reversible contraceptives that are subdermal at least be offered to any woman giving birth at the hospital. And Representative Fleming, who's a retired OBGYN from Jeffersonville, brought this legislation and is very passionate about this topic in an attempt to reduce the number of unexpected pregnancies and sort of the pregnancy spacing concept there that can sometimes lead to unfortunate outcomes. So this was one that was, this bill was very much viewed in sort of the public health lens, and it did include provisions requiring reimbursement from Medicaid for those contraceptives that were both for the contraceptive and for placement of the contraceptive. And the bill specified that such reimbursement is not to be sort of bundled with other services provided to the woman, but has to be a separate reimbursement specifically for the contraceptive and the placement. Also has to include stocking of the contraceptives as well. Senate Enrolled Act 273 has to do with biomarker testing coverage. And so it mandates coverage for biomarker testing for the purpose of diagnosis, treatment, and management of an individual's disease or condition if the biomarker testing is supported by medical and scientific evidence. And so these biomarker tests are sort of the science behind them and the availability of these tests, whether it's for certain cancers or for Alzheimer's. You may have seen in the news that Roche and Eli Lilly just received breakthrough status for a new Alzheimer's related blood-based Alzheimer's biomarker test. It simply requires that if a physician would like to order one of these, that they're to be covered when they're backed up by the appropriate medical and scientific evidence. Essentially, the science in this space is rapidly evolving faster than the insurance coverage policies can keep up. And this is applicable to both Medicaid and commercial insurance. And the discussion in this space is that this sort of personalized approach to testing and medicine will yield savings in the long run by narrowing in on the appropriate treatment as soon as possible for each individual. House Enrolled Act 1216 is a follow-up to House Enrolled Act 1006 from last year. I know this is kind of could be a topic that could be a whole other presentation, but you may recall that we had legislation that updated our emergency detention order statute last year. Which again, I won't get into for time's sake. I think IRHA may have some other materials on that topic, but this follow-up legislation specified that when detaining an individual, that information may be provided to healthcare providers from family, friends, and others to influence an emergency detention order request. And most importantly, the legislation last year was intended to specify that Medicaid and insurers should reimburse for services that are provided pursuant to an emergency detention order. It only makes sense that if a court orders an individual to be detained for their own health and welfare, then that provider that is taking care of them should be paid. And unfortunately, there were instances where the industry was seeing that these managed care entities were not actually paying for those services. And so this tightens up the language to say that that if care is provided if the care that is provided is required by the plans to be in accordance with clinical care guidelines, then the guidelines have to be published not by the managed care entity, but by Medicaid. You may have run into an instance where one of these individuals is being treated in your psych unit and the managed care entity denied based on medical necessity, and they cite clinical care guidelines. And then you ask, well, can you share the clinical care guidelines? And in some instances, they were saying, no, those care guidelines are confidential and proprietary. And then it's sort of this vicious circle of, we don't understand what they're looking for in terms of medical necessity and proving that this person it's medically necessary for them to have treatment. So this attempts to solve that by requiring Medicaid rather than the MCEs to publish clinical care guidelines. Senate Enroll Act 215, I will jump over real quickly here, but essentially this addresses Medicare supplement insurance, or Medigap, for ALS or end-stage renal disease patients. Essentially, there are individuals who have these conditions, are able to get Medicare, but oftentimes they need Medigap policies in order to survive financially. And so this really requires that these policies be offered at a rate that's equal to the price if you're age 65 or over for that coverage, in an attempt to increase access to these really important policies for folks with these very serious conditions. House Enroll Act 1058 from Representative Nagel has to do with breast cancer screening and services, and requires facilities to notify patients and their providers of breast tissue density so that both patients and providers can be more aware of their risks for issues down the road. So that was an important bill supported by the Cancer Society, and there was a lot of testimony from folks that were cancer survivors on this issue. And so I think that was a good piece of legislation across the board. House Enrolled Act 1070 had to do with mental health grants, and specified that for-profit community mental health organizations may be awarded grants from DMHA so long as there are no nonprofit organizations that qualify, to make sure that our resources that are available through DMHA for community mental health purposes can actually get out the door, even if there's not a nonprofit in a particular community that's able to facilitate that. House Enrolled Act 1205 had to do with mental health standards and reporting, and essentially has a laundry list of information that community mental health centers have to submit to the Division of Mental Health and Addiction in the annual report that they submit to the agency. House Enrolled Act 1258. This is not directly in the healthcare space, but has to do with sort of public health. And the goal, I won't go into too much detail on this bill, but the goal of this bill was essentially to put in place a standardized system for regulation of food trucks, so that food trucks, as they're becoming more and more popular, can travel from county to county and not have to deal with this sort of patchwork of regulations that govern how they operate. House Enrolled Act 1332 was the Department of Insurance agency bill. A lot of it was focused on property and casualty insurance and issues unrelated to health insurance, but it did, at the end of the day, this is another one of those omnibus bills in the healthcare or in the insurance space, but it included a provision specifically applicable to healthcare providers and health plans, requiring that providers and plans provide 90 days notice to a health plan or prior to terminating a contract, and vice versa. If a health plan is going to terminate the provider's contract, they have to give at least 90 days notice. This was based on concern for consumers. There were some legislators who had patients who would, or had constituents who would join a particular health plan to follow their provider in the plan, and then all of a sudden their provider is no longer in network with that plan after they had just joined and signed up for the year. So really based on consumer protection. Now I'm going to shift gears just a little bit and talk about a couple issues that were introduced this year, particularly this House Bill 1393, the hospital assessment fee, was introduced and took up a lot of time for discussion. There was a whole committee hearing in the House devoted to this. They kind of created an additional, I mentioned before, they only had 3 committee hearings on each side. They created a 4th hearing only specifically for this bill because it's such a complex topic. But this was a top priority for the Hospital Association. And really, this is intended to modernize our hospital assessment fee, which is where the hospitals essentially pay a provider tax in order to leverage more federal dollars to increase reimbursements to physicians and hospitals. And so essentially, this would move Indiana into what is called a state directed payment model. And by modernizing sort of how these payments are made, and then how the reimbursement based on quality metrics, and dealing with an administrative fee that's kind of skimmed off of the top of what that it goes to the Indiana Medicaid. There's dealing with that administrative fee, which has kind of gotten out of control, is essentially just cleaning this up in hopes that we can increase Medicaid reimbursement from where it's now currently about 57% of cost, according to IHA, or hopeful to increase it to about 80% of cost. This whole modeling, well, and again, this could be a whole different topic for discussion, a whole different presentation on its own. But a couple other elements, they would implement a managed care assessment fee as well. So managed care organizations would also pay a tax that would leverage actually more federal dollars than provider taxes do. That would help cover the administrative fee paid to FSSA. And then it would also, this model put forward by IHA would sort of move Indiana away from reliance on Medicaid disproportionate share payments or DISH payments, which, their future of those type of payments are uncertain at the federal level as well to some degree. So again, this could be a whole different topic. It's certainly very complex. But suffice to say that it did not pass this year. The legislature generally was concerned about taking on such a weighty fiscal related topic outside of a budget session. And even though a lot of this a lot of this maximizing of the drawing down of federal dollars, it was not intended at all to dip into state funds. It was simply intended to maximize how fees that hospitals pay into the system are utilized. The legislature was still hesitant to do so, and they sort of kicked the can down the road to next year. So I know IRHA is going to be very involved in planning for these discussions and how to best protect the interests of rural hospitals in these discussions. You know, I think the silver lining here is that while this could have provided a significant financial relief, you know, the silver lining is now that there can be kind of extra time and attention devoted to this to make sure that that we get it right and that it's as beneficial for everyone as possible. Another bill that was that did not pass but was introduced was Senate Bill 168 regarding the 340B program from Senator Charbonneau. This is interesting in that it requires 340B covered entities to annually report a laundry list of data to the Department of Health, including aggregate acquisition costs of 340B drugs, aggregate payment received for 340B drugs that are dispensed, aggregate payments made to contract pharmacies, number of claims total for 340B drugs, and how covered 340B covered entities use the savings from the 340B program. You know, this is odd in that it's a state law that is requiring reporting for a federal program. So I think well, this was scheduled briefly for a hearing, but never actually made it onto a committee calendar. So while I think you know, it remains to be seen. I know there's federal legislation that Dan and IRHA are tracking right now, the Sustained 340B Act, that has some reporting metrics that are similar to this involved at that level. But I'm not sure if there's a path forward at the state level for this, but it does, I think, signal concern and this that the healthcare, some of the interim study committees looking at healthcare costs have flagged the 340B program as one that there have been some think tanks that have come and testified that said that there needs to be more transparency in the 340B space, and this may signal that the legislature is concerned about that. So we'll see how this plays out. But it was sort of an interesting concept to have state reporting for a federal program. So, you know, the hospital assessment fee and then 340B may be two issues that we see come up next session, although it's entirely possible that that could be tackled, at least the 340B could be tackled at the federal level. So looking ahead, we are coming into the 2025 budget session, given the Medicaid budgetary shortfall issue that I discussed that impacted a lot of the bills that we've talked about. You know, I think the hospital assessment fee modernization, now that it's had sort of one session to be discussed and kicked around, and now another interim to be further refined and further advocated for, and the fact that it can provide more leverage, more federal funding without necessarily any state expenditures, that is certainly ripe for action in the 2025 session. As well as generally, you know, what are legislators going to do about this Medicaid forecasting error? Are there a chance that they're going to come in and cut reimbursement? We would certainly hope not. That would probably be counterproductive. You know, are they going to scale back types of services, or are they just going to simply appropriate more money to make sure that it's covered? You know, or it's that could go any number of ways, and so that's going to be something that we're going to have to stay on top of over the interim. The cost of healthcare, we've talked about that kind of ad nauseum over the last 5 or 6 years, but continuing to track the discussions of the Healthcare Costs Oversight Committee and the latest data. You know, once the all-payer claims database gets set up here, hopefully in the near future, what does that look like? And then, of course, it is possible the abortion topic could come back up again. There was some discussion during this session. You may have seen in the news recently, there's a debate as to whether termination of pregnancy reports, or TPRs, that are filed with the Department of Health, whether those are public records or whether they can just be reported in aggregate quarterly by the Department of Health. So that could very well how those records are maintained and how they're disclosed could come up in the next session. And so finally, again, just kind of full circle here, we've got the gubernatorial primary coming up on May 7th. We've also got primary elections at the legislature. There are 10 open seats right now, 8 in the House, 2 in the Senate. 22 members and 7 senators are facing primaries. We have 4 contested congressional primaries. And then, of course, the general elections, November 5th. And so early in-person voting's already started. So it's going to be interesting to see, depending on the results of those primaries, how that signals any shifts in how the legislature will tackle these issues. So that's it for my presentation. I apologize. It looks like I may have gone a little bit over time in terms of discussing the issues, but happy to take a look at any. I can't see if there's anything in the chat here, but happy to take any questions to the extent we have time here. Allie, Dan, any questions in the chat?
No questions in the chat or the Q&A, but Dan, if you have any follow-up questions or comments while we keep an eye here on the participants to see if anything else comes in, please feel free.
No, nothing to add, Grant. I think you did a fantastic job explaining what the session entailed. I think next year is going to be very important. All the things you laid out, especially impact for rural Indiana, could be substantial. So hopefully everybody can remain engaged with us and continue to help us forge a path forward. Hopefully that encourages collaboration between rural health providers and those at the State House.
Yeah, absolutely. And yeah, I think IRHA is going to be a very important voice in those discussions. You know, legislators obviously seek out your organization's input because they're very, you know, I can certainly say throughout all these discussions on healthcare costs and Medicaid, there is a significant concern, thanks to the work of IRHA, about impact on rural health. That is something that legislators have prioritized. They want to make sure there are no unintended consequences of their actions that would then jeopardize rural health. So thanks again for all your work in the space, and looking forward to working with you.
Okay, well, I've not seen anything else come in, so I will just thank everyone for their time today. Again, this will be posted to our YouTube channel by the end of the week. If you have any other questions, please reach out to Dan or Grant. Thank you all.